This is the second in our four-part series where we're talking about the Employment Rights Act and the changes that we need to be ready for, either as HR professionals, HR managers, or small business owners for 2026. I'm going to ask you to bear with me on this session. I unfortunately spent last week in hospital, so this is my first day back. I'm absolutely fine, but my brain is a little bit foggy this morning. And a huge thanks to the wonderful Dawn and the rest of our team who held the fort last week, and Dawn for making sure that this event actually happened this morning. So it's great to see so many of you on here. And like I say, bear with me if I'm not quite as sharp as I normally am. We will try and get to any questions, but if not, as always, if there are any questions that we can't answer or we don't have time to get to, then we will follow up with you individually. This is session number 2. Session number 3 is called Business Protection. That's where we're going to be talking about the new sexual harassment provisions, protected disclosures and NDAs. And then session number 4 is working styles. So where we're going to be doing 0 hours, agency workers and trade unions. We will be releasing the dates for those shortly after this session. So if you want to make sure that you do the full 4-part series, then please don't hesitate to sign up for those. And they will all be available on demand as well. So in this session, we're looking at flexible working and family-friendly rights and the changes that we are seeing this year. So we're kicking off with a poll. So first of all, we've got flexible working in your organisation right now. So do we actively encourage it where possible? We consider requests but often refuse. We allow limited forms only. So for example, hybrid but not changing hours. And we deal with requests case by case but no clear policy. Or honestly, we try to avoid it. So pop your answers in there. So let's have a look at where the trend is for this cohort today. So nice that we're not seeing anybody avoiding it or not admitting to avoiding it. And case by case. So no clear policy. Yep, that's not so much of a surprise. So interesting answers there. So first of all, what we're going to do is following on from our last session where we looked at unfair dismissal protections and the changes around that, fire and rehire restrictions and lifting and compensation limits. If you missed that session, we went through a lot. It was very fast. That is available on demand, so don't hesitate to take a look at that. So in the follow-on, this session today, we're doing understanding flexible working and the changes to family-friendly rights. So to understand what's changing, we need to understand what the rules are now. So at the moment, flexible working, so what is it? This is where we may have people who want to job share, so people splitting roles, where we have people working remote or hybrid, where they want to change their hours, so reduced to part-time, where they want to do compressed hours, so the same number of hours but in less days, work flexi time or staggered hours, do annualized hours, phasing even out into retirement. So basically anything other than, if they're not in the office 9 to 5, any changes to that arrangement. So it's not just a change to hours, it's not just a change to location, it could be anything when we're looking at flexible working. That's what we're talking about here. At the moment, we've got 8 reasons why flexible working can be refused. So those are on the screen on the right-hand side. This deck will be available afterwards as well, if any of this information is going to be useful for you to refer back to later. So the only reasons we can lawfully refuse flexible working at the moment is burden of additional costs, detrimental effect on ability to meet customer demand, inability to reorganise work amongst existing staff, inability to recruit additional staff, detrimental impact on quality, detrimental impact on performance, insufficiency of work during the period when an employee proposes to work, and planned structural changes. So hopefully nothing new to us there. These were in the Employment Rights Act 1996, and spoiler alert, under the Employment Rights Act 2025, these are staying in. However, the basis upon which we can refuse is changing slightly. So current legal framework is day 1 rights. So anyone can request a flexible working from their first day of employment. This was a change in 2024, and that removed the previous 26-week qualifying period. Employees could make 2 requests annually. So again, this was a change from the pre-2024 position when they could only make 1 request. So it's 2 flexible working requests in a rolling 12-month period. We have a mandatory response time of 2 months, and we must meaningfully consult with employees before we refuse any requests. So we've got to go through a process, and we've got those 8 limited grounds of refusal. So what's going to be changing? Well, Section 9 of the Employment Rights Act 2025 does make it a little more difficult now for us to refuse. So we're going to do a bit of law here. So we're actually going to look at the Act, and what is inserted by the 2025 Act is that employers may refuse the application only if. So the starting point here really is that we are agreeing it. The starting point is agreement, and we can only refuse it if the employer considers the application should be refused on the grounds listed in subsection 1ZA. So those are the 8 grounds that we already have. And it is reasonable for the employer to refuse the application on that ground or those grounds. This is new. So to show that we are being reasonable in that refusal, and that burden is going to be on the employer to be able to show that they are being reasonable in the refusal of that application. So starting point generally, so where we're seeing in the press and the HR press and things like that about this default right to flexible working is this is where it's coming from, is that wording where it's we can only refuse the application if. So it's that inference that we've got to start from, well, let's look at this positively. And that there's then got to be a reasonable grounds for refusal. We've then got an additional burden under Section 4 that says if the employer refuses an application under Section 80F, the notification under subsection 1AA must state the ground or grounds for refusing the application and explain why the employer considers that it is reasonable to refuse the application on that ground or those grounds. So in English, if we're going to refuse an application, we have to state what ground or grounds we're refusing it on and why we consider it to be reasonable. So we have to lay out our case at this point when we're refusing an application to say the grounds upon which we are refusing and why it is reasonable. So previously, employers only had to deal with requests in a reasonable manner. So reasonable process and being reasonable about the decision making. We now have to justify the decisions that we're making and specifically say why we consider them to be reasonable. And the way that we're going to be doing that is not just to say, oh, well, because of it's going to have an impact on performance. Well, why is it going to have an impact on performance and why we think your request is going to have an impact? And here is the data, here is the evidence, and here are the reasons why. We're going to have to be much, much more prepared if we are going to be refusing flexible working requests to be able to give good, solid evidence and data behind the reasons. Otherwise, we're not going to be able to show why it is reasonable. So a lot more work required. The consequences if we get this wrong. So this is something that someone has the right to do from day one. We've seen that the cap is being lifted on unfair dismissal. So if someone resigns in response to either a breach of the legislation or you're treating them badly because they've made a flexible working request, as we saw in the first session, we've got the lift of the compensation limits. The burden is on the employer. We have to prove why what we've done is reasonable. And also, if an employee says that there is a detriment or they were dismissed because of their flexible working request, we're going to have to show that it wasn't related to that. It's also an automatic unfair dismissal reason. So if we have someone at the moment who's employed less than 2 years, by the time we get to January 27, less than 6 months, then if someone has been dismissed for making a flexible working request or put to a detriment because they have raised a flexible working request and resigned, they will be able to bring an unfair dismissal claim without that qualifying period. This is one of those special reasons that is protected within the law. So we've got that broad protection where it extends to detrimental treatment and not just dismissal. It applies, the protection holds even if the request was refused. So it's really, really important that one, we get to grips with what those 8 grounds mean, but also how they apply to our business. So having a think, what are the circumstances or what are the sorts of working arrangements that are not going to work and how would we evidence this? And we've got to stop gatekeeping that evidence, which I do see quite a lot when I'm working with clients around things like this, is they don't want to hand that information over as to why something might not be working, either because it's business plan related or they think it's sensitive information. But typically, there is something that we can give somebody to explain our position or perhaps get them to understand why we're having to say no. We also need to be changing our mindset around flexible working. So have a think about through your organization what roles you have, what purpose are they serving, how are those people currently working, is there a way that the roles can be more flexible? I mean, you may want to be proactive, and this is something that you are offering out without being asked by employees, but also thinking if we are asked the question for every single role that we have in our business, what do we think will work and what do we think isn't going to work and why? So that when those requests come in, you've already started to build your armory around, well, what do we think is going to be reasonable and what do we think is going to be more difficult and why? So we're going to move now on to family-friendly rights, but to wrap up on the flexible working stuff, we're going to need to review our policies. One of the freebies that we're going to be giving away from today will be a draft flexible working policy. So that'll help you with a starting point if you don't already have one. But like I say, this is one where, particularly because of the way that things are reported in the press, that employees are perhaps going to have a very fixed view around the fact that they believe that they have a right to flexible working rather than the right to request. And what we've actually seen from a legal perspective is a shift in the burden how we've got to be reasonable and how we've got to explain ourselves if we aren't going to be approving something. So next, moving on to family-friendly rights. So this is where we're talking about the different types of leave that people can take, either to support their families or in the event that something happens within their lives that means that they are going to have to take a period of leave. It can impact small businesses in a more significant way, purely because often we're stretched with resources anyway. Then when somebody's off and it's a bit unplanned or it's a bit inconvenient, obviously that has a bigger impact than perhaps larger businesses that have got the resources to absorb that additional workload or can more easily bring temporary assistance in. So the key rights, this might be a little bit small on your screens, but like I say, this is going to be available after the session. So the key rights that you should be aware of anyway. So we've got paternity leave. So maternity, shared parental, adoption leave is there's not a huge amount changing. The reason paternity is on here and they're not is because of the changes that we're going to be seeing. But paternity and isolation, employees become eligible for paternity leave after 26 weeks of continuous employment. This is the position at the moment. And they get 1 or 2 weeks paid leave, and they can be taken in blocks. So they can take a week when baby is born, and they can take a week at another time. Parental leave, this is an unpaid right. At the moment requires a full year's service before an employee can access their entitlement. They get 4 weeks per year per child up to the age of 18. It's booked in advance in week-long blocks with 21 days notice, and we've got limited ability to be able to postpone or agree with the employee when these are taken. This is one of the most underutilized types of leave by employees. Mostly because people don't know it exists, and it's something that some employers like to keep quite quiet, particularly with larger families. If you think that someone who may have 3 or 4 children, they get 4 weeks per year per child up until they're 18, that's quite a lot of leave, albeit it's unpaid, but it's something that can potentially cause quite a lot of disruption. It's also one of the things that when someone's being onboarded is rarely checked with former employers, because this isn't a right that refreshes with a new employer. So when somebody moves from one employer to the next, it's a good idea to check whether parental leave has been used before somebody comes over within that year. So at least then you kind of know where the balance is for the person that you're inheriting. Statutory sick pay. So currently SSP starts from day 4 of illness. We have those waiting days. We've got the lower earning limit for eligibility of £125 a week. And the current SSP rate is £118.75. So that's the current position. Bereavement leave, we get 2 weeks of statutory paid parental bereavement leave. So this is for a death of a child under the age of 18 and stillbirth, so where somebody miscarries after 24 weeks. They get £187.18 or 90% of earnings, whichever is the lower, and the leave can be consecutive or it can be separate. So again, current position. And then dependence leave, which isn't changing, but just to kind of round off the different types of leave, because this can sometimes be confused with parental leave. This is the time off to deal with unexpected emergencies. So this could be mother-in-law's fallen down the stairs. I found her in a heap, and I have to take her to hospital immediately. I'm not going to be in today. I need dependent leave. It's to deal with the immediacy of an emergency. We don't take dependent leave when we know we can't get childcare in 2 weeks' time, because that's not dealing with an emergency that's happening now. And they're allowed reasonable unpaid time off to deal with that emergency, deal with the immediate crisis, and then they're expected to put measures into place to enable them to come back to work, whether that's then asking for annual leave, or, like I say, if it's something that's further down the line, trying to schedule some parental leave to deal with that issue. So those are the family friendly rights that we have there. We've got a question there. Do they accrue holiday during unpaid parental leave? Yes, they do. So during any of these leaves, while somebody is off, they are going to be accruing annual leave. So under the 2025 Act and from April 2026, we now have day one paternity rights. So we don't have that 26-week period that people have to wait. There's a little quirk around shared parental leave that I'm going to cover in a separate slide in a moment. And it's the same for parental leave as well. So for those booking those 4 weeks per child, those are also available from day one rather than after a year. SSP will also be payable from day one of sickness. So we don't have those first 3 days that are unpaid, and the lower earnings limit will be abolished. So what this means, where we've got a workforce of people who are perhaps on minimum wage, not working necessarily very many hours, and if those employees were off, they weren't impacting our bottom line because either we weren't having to pay sick pay because they were under the lower earnings limit, or people who might get Mondayitis or perhaps a hangover after going out into the city on a Thursday and not coming in on a Friday, they are going to get paid for those days. So we see a lot in the press around how the government thinks that actually by paying sickness from day one, it's going to reduce sickness rates. With my experience with smaller businesses, and particularly with workers at the lower end of the earnings scale and perhaps in the more unskilled sectors, I do think we are going to see an increase in sickness levels purely because these days now are going to be paid for people when in the past they wouldn't have been paid. So just being aware for your payroll, from April, SSP is from day one, not day 4, and that lower earnings limit has been abolished. And the rate obviously will be going up in April as well. Bereavement leave has also been expanded. I mean, this is one that I really can get on board with at the moment. It depends on how they're going to word the regulations. So at the moment, essentially, unless you lose a child or have a very late stage pregnancy, there's no right to any time off. This is now going to be extended so that basically if you lose somebody close to you, there is going to be the entitlement to unpaid bereavement leave. The definition of someone close to you has not yet been settled. So this is going to come in regulations, because what the government is saying is that we need to recognise that families are not always made up anymore in the traditional sense. Whether this will mean that you're entitled to bereavement leave because your dog has died. I mean, I'm sorry. No, if it's dog, yes. If it's cat, no. Okay. If it's your, neighbour's second cousin who you saw twice a year, well, is that close enough, even if you're very fond of them, compared to perhaps when a parent dies? They seem to be struggling with where this line's going to go. At the moment, it looks like it's going to be very broad. I suppose the protection for employers is that it's unpaid. So there is that kind of disincentive there to kind of use this maybe too regularly. But I think we've probably all dealt with that person who's had several grandparents die and it doesn't all quite stack up and they ask for lots of time off. So it'd be interesting to actually see where the line gets drawn for this one. And then parental leave flexibility, which I'm going to come on to now on the next slide. So there was a strange quirk in the law that meant that if shared parental leave was used first after a baby was born and paternity leave had not yet been used, that the employee would lose the right to use that paternity leave. So the new rule is that parents can now take paternity leave after a period of shared parental leave. So If you have, for example, mum and dad who have a baby, and mum decides that she's going straight into 20 weeks of shared parental leave, and dad decides to share the first 2 or 3 weeks with mum, so they both want to be off after the birth for a period, under the new rules, dad can still take his 2 weeks of paternity after that shared parental leave has ended. So it doesn't extinguish the right to that paternity leave, which it's a bit of a strange one to say that by using the shared parental leave that you can't then use the paternity after, because they are technically two separate periods of leave. What it's going to do is makes it a bit more flexible. Parents can choose the order that works best for them. It's easier to adapt if circumstances change, and it's a bit simpler as well, that you don't have to remember that if shared parental leave has been taken first, that they then can't take paternity. Or incidentally, if you've got someone who's arguing the point over how much leave they've got left, it should make it a little bit more straightforward. So bereavement leave, again, just to go into this in a bit more detail. So the current rights, so we've got, if somebody loses a child or a baby is stillborn after 24 weeks, they get 2 weeks leave. There's no general statutory right for other bereavement. It absolutely at the moment rests on employer policies around bereavement, and that is absolutely discretionary. And of course that there was no recognition for pregnancy loss before 24 weeks. We had a recent addition that came into force in December 25, and this is around bereaved partners. This applies where the mother or the primary adopter has died shortly after birth, and the father or the partner can then take paternity leave without the normal qualifying period, and they can take the paternity leave even after shared parental leave in these bereaved cases. It's very specific to these absolutely awful circumstances, so hopefully something that none of you will ever have to administer, but just to be aware that if you have a parent in that situation, the law did change in December on that. In 2027, we're going to see the expanded general bereavement leave. So it'll be a day one right, statutory right for death of someone close to, but that's obviously to be defined. Minimum of 1 week unpaid leave, and it's got to be taken within 56 days of the bereavement. And we're waiting on detailed regulations around what it means for someone to be close to you. We've obviously got the new coverage around pregnancy loss, recognising the grief and trauma that families go through with early miscarriage. And again, the duration and rules are being finalised in secondary legislation, and that is expected in 2027. So what can we do to prepare? So making sure that we review and update our flexible working policies. So going through and having a look and seeing where your policies are up to. I routinely see flexible working policies that weren't updated with the 2024 changes, and these changes now are even more significant. So making sure that we're getting that wording absolutely right, and also that we're starting to prepare in draft for the new family friendly policies, and also considering, in very plain language, putting out perhaps publications to our employees to explain what their rights are. So we get on the front foot about it, invite questions, say, look, these are your entitlements. If you have any questions, that we're happy to address them. We need to be making sure that we are training managers comprehensively around flexible working. We have to make sure that we're eradicating the attitude that if somebody is asked, I'm thinking making a flexible working request, that you have any managers who are going to say, well, we don't accommodate that here, we're not setting any precedents, or well, I wouldn't ask. Because of the way that the law has changed, we can no longer have that within the workplace, because it will represent a significant risk. We need to be making sure that managers are aware of what employee rights are and how we need to be dealing with them and what those processes involve, and that they need to be dealt with in a reasonable manner with a reasonable explanation if we are going to be saying no. So training is going to be really, really key for that, but also making sure that managers understand the different types of family friendly leave rights, because a number of times where you've had someone perhaps who will ring and say, I've got to take dependent leave, something's happened, and then someone's been pulled into a disciplinary because they haven't notified their absence by the right time, and it's dealt with like it was sick leave when someone has specifically said it was dependent leave. We don't need to be having that kind of mess in a year when we're dealing with so much change. So making sure whether they have a reference point where they can check what the different leave types are, what they mean, I mean, some flashcards might be something that we can look at preparing around something like this. If anyone thinks that would be useful for something that they could share with their managers as a quick reference rather than, a full-blown guide or policy. If you think that would help you, chuck a thumbs up in the chat, and if there's enough of an uptake for it, then we'll do those. And then also making sure that we're updating family leave policies as well, so that we're well ahead of this by the time we get to April. So we've already had a slight expansion to the bereavement leave rules that came in December 25. We've now got just under 4 months actually until a raft of the next changes come in April 2026. And then, as I said in the other session, and we will be saying in the next 2 sessions, we've got 24 months of change now, where we will be having to make sure that we are on our toes and really, really clear on what change is coming and what we need to do to prepare for it. As always, we are here to help you, so thank you so much for listening. We are a complete wraparound service, either for HR professionals, if you're running your own consultancy, HR managers within businesses and small businesses. So we're here to either support with consultancy and legal advice, HR SaaS software, and also trainings. We have an e-learning provision as well that is expanding month on month. So if there's anything that you need, if there's any way that you think that we can support you, we're absolutely here to help. As always, though, if you're fully sorted, that's absolutely great. You're always welcome on our webcast. The podcast is also always available. So hopefully there will be plenty of content and sort of ad hoc content that you can take from us as well. And that's the session for today. I feel like we had a bit of a better pace. The unfair dismissal one was really, really fast. So if there are any questions, I'm happy to take them. So I'm just going to have a quick flick through the chat now and just see. So I've got from Steph: if you advertise a role and hire someone based on set working hours, can they on their first day request a flexible working request? Yes, they could. So even if you've advertised it as a specific business need, it doesn't preclude the fact that they can make that flexible working request. Hopefully, because the thought process will have gone into those set working hours, we're going to be relatively clear on why we can't approve a flexible working request, but we would have to actually go through the full process. So hold the meeting, explain ourselves, and give the right of appeal. They would absolutely have the right to do that. And remember, if we were to put that person to a detriment because they've done that, so if they're given the cold shoulder, or perhaps they're not treated perhaps as warmly as they would have been because they've done that, as annoying as that situation would be, they would potentially activate their legal rights. So we would need to be careful about that. So we've answered that one. I think that's all the questions. So hopefully this has been a useful session for you. There is still a live poll on the screen if you want to drop anything in there. As I've said, the next session is going to be on the changes to sexual harassment, protected disclosures, and NDAs. And then the session after that, we're going to cover 0 hours and then my 2 least favourite topics in employment law, which is why I've put them last, agency workers and trade unions. So thank you so much for joining us. Like I say, if there's anything that we can help you with at all, please don't hesitate to let us know. But thank you for giving me half an hour, of your morning on a Monday. And if my brain has been mush and this hasn't made loads of sense, then I do apologise. As I say, it was a bit of a tough week last week. But the morning is now yours again. Everyone is free to leave the session, and thank you very much.